Welcome to JGL Law for You. JGL Law for You is a podcast by lawyers, but not for lawyers only. On JGL Law for You, we will be discussing a wide array of topics to help you navigate the many legal processes, developments in the law, other current events, and how they may affect you, your family, or your business. Today we have an interesting discussion with two of my partners, two principals at Joseph Greenwald and Lake, Veronica Nannis, who focuses her practice on complex litigation, has been doing so for more than 20 years now. Over the last 10 years, she has done complex class action cases. She's represented whistleblowers under the False Claims Act, and she focuses a lot of her practice on healthcare fraud. Joining her is Drew LaFramboise, also a principal and a partner of mine at Joseph Greenwald and Lake. He focuses his practice on complex personal injury cases, wrongful death, civil rights, commercial matters, and other complex class action cases. And today, folks, we're talking about a case that has been in the news, and very interested to hear the information about this case, the background of this case. And it's a major class action case versus the Psychiatric Institute of Washington. Now, folks, before we get into the case and what it's about, for those who don't know, what is the Psychiatric Institute of Washington?
Well, good morning, David, and it's great to be with you again on the JGL podcast. Always happy to be here. So the Psychiatric Institute of Washington is the only private facility in the District of Columbia that's dedicated to psychiatric and behavioral health treatment. It's been around for decades, and it's a large facility, 130 plus beds, treats thousands of patients per year. And importantly, for the purpose of our case, which I know we'll get into in a little more detail as we go, in 2014, it was acquired by Universal Health Services, or UHS, which is another defendant in our case. And UHS is the largest for-profit owner and operator of psychiatric facilities in the country. It's a global company, Fortune 500 company, at revenue in the multi-billions per year, facilities all over the world. So since 2014, Psychiatric Institute of Washington, or PIW, has been operated, owned, and managed by UHS. But yes, to your question, it's the only private psych facility in the District of Columbia.
And they serve both inpatients as well as folks who are daily in and out type patients, or do people spend the evenings in?
That's correct. And that's an important distinction here. So yes, they have both outpatient programs and inpatient services. The focus of our case, which I know we'll talk about in more detail, is the inpatient side of PIW, which is the largest component of its business by, I think, orders of magnitude in terms of the patient population that it serves.
And again, just to give a broad picture, in terms of employees, doctors, assistants, what's the staff look like?
So there are physicians there, certainly. There are psychiatrists and psychologists. There are social workers. And then there are nurses. And then there's a large component of the staff in terms of the inpatient services are what are referred to as techs. And these are folks who handle the day-to-day operations of the facility in terms of interfacing with patients, working with patients, delivering food, delivering medication, things of that nature. They're the ones who are kind of on the floor day in, day out.
Okay. All right. So now I've got a picture of the facility, who runs it, who operates it, who works there. What's the case about?
Sure. I'll take this one too. I know I'm soaking up a lot of the oxygen here, but Veronica's going to do a lot of talking, I think, eventually. So we represent a woman who's a District of Columbia resident, an adult woman. In the complaint, she is named Jane Doe. That's obviously a pseudonym to protect her identity. So we'll call her Ms. Doe for the purpose of this conversation. In April of 2024, Ms. Doe had an argument with her estranged husband, who she was engaged in divorce proceedings with. And the argument was over certain things that don't really matter for the purpose of the case. But in any event, her husband called the police and he made a report about her that was false. The report was that she was suicidal and that she had underlying mental health conditions, neither of which were true. The police found her, detained her, and took her to a District of Columbia run facility, an emergency facility called CPEP. She was held at CPEP overnight, and she was restrained, put into an ambulance, and taken to PIW. This is a very common thing that happens in the District of Columbia. And in fact, PIW has a contract and has had a contract for years with the district for this very purpose, to take what they call emergency psychiatric admissions, inpatient admissions. So folks who are picked up by the police, who are referred to CPEP by physicians or other facilities, they can then go to PIW per the multi-million-dollar contract that PIW has with the district. And Ms. Doe is one of those folks.
Let me interrupt you for a second. So
Sure.
husband calls the police, says, my wife, you need to get over here. My wife is having some sort of an incident. Something's going on. The police show up as a result of that telephone call. And then what happens? Do the police talk to her? The police talk to him? Or they just wrap her up and throw her in the back of a car?
Yeah, closer to the latter. So they restrain her, put her into the car, into the cruiser, don't really tell her where she's going. She shows up at CPEP. She's shuffled into CPEP. They do a 5-minute evaluation. They put her in a padded room. She's kept there overnight. No real information shared with her. And then she's taken to PIW the next morning. She gets to PIW. Very surface level evaluation done. Takes a couple of minutes. They document that she's suicidal, despite her saying over and over during the evaluation that she's not suicidal. And they commit her involuntarily against her will.
I'm listening to this, under a family lawyer's lens, right? Saying if it was this easy, the hospitals would be filled with people, because every time there was an argument in the midst of a divorce or separation situation that isn't particularly pretty, one of the people's getting hauled off and locked up.
And in fact, there's a form in the District of Columbia called FD-12. And that form is used to involuntarily commit a person on an emergency basis. So the police use it often. Physicians and hospitals can use the same similar form, but there's a box in the FD-12 form that says, what's the basis for the emergency commitment? And the police officer wrote, husband reports suicidal ideation and mental health history. So it was entirely based on the false report, according to our allegations from the husband. Again, as Veronica said, no independent assessment or evaluation was done to corroborate anything.
Neither at the police level nor at either of the two mental health stops that she makes between the pickup and then when she gets dropped off over with the U at PIW.
That's correct. And in fact, at every step of the way, Ms. Doe is adamant that she's not suicidal, that she has no plan, that she has no ideation, and people just keep checking off the suicidal ideation box. And in fact, and this is actually important because under District of Columbia civil commitment law, which we cite in our complaint, a medical provider such as PIW, they should always err on the side of the least intrusive measure of treatment. And so if a person says that they have no plan, that they have no suicidal ideation, that they don't meet the criteria for involuntary commitment under the law, PIW cannot commit them. And in fact, I believe the civil commitment law is shall not commit them. And so what PIW is doing here is they're A, failing to take the patient's word for it, and B, failing to follow the law as a result. She did not meet the criteria for suicidal ideation. And that's what we've alleged in the complaint. But nonetheless, she's committed to PIW. The term of the commitment was supposed to be 7 days. This is a person, by the way, and we should have given a little background on Ms. Doe. She's a working professional in the city, 2 young kids, no mental health history, has never been diagnosed with anything other than, generalized anxiety, which we probably all have.
99% of the population in this country.
David, to your question, though, during this whole litany that Drew is explaining, to my horror, right? Hopefully to many people's horror, the police did not do any sort of independent assessment, which I assumed they would have. I think your question assumes that they would have. They don't. CPEP doesn't really do one of any substance whatsoever. Everyone is tragically taking one accuser's word for it so far. And Drew's brought us all the way to the next morning, where based on one, you do divorce work, David. As divorces go, they are messy 100% of the time. And it's a little horrific, but that sort of Drew completely lays out Ms. Doe's allegations here. That's exactly what happened. So you can see 2 or 3, fail-safes that should have kicked in are not doing so. And now we brought her all the way to the next morning, and she's involuntarily committed at this place. No one knows where she is except for the ex-husband who accused her and got her committed.
And she's terrified. She has no idea what's going on. She's trying to figure out how to contact her employer, how to get a hold of her kids. but she's essentially just thrown into this system now, and she's involuntarily committed. Her freedoms are taken away, her liberties taken away. She's now, going to be living at PIW for the next several days, and she has no idea what that entails.
Another important point about Miss Doe, so she, as a working professional, she has good private health insurance. And I will just tell you that a lot, not everybody, but a lot of patients who end up in any type of mental health situation generally are having Medicare or Medicaid or some sort of federal or state assistance. That's their insurance. But Miss Doe, as a working professional, had one of the sort of premium private insurances that we all know. And that's going to be important in a little bit. But to give you a little flavor of what she was going through, it's important to know that she's got good insurance too.
Yeah, no, I'm going to assume that at some point the folks at PIW learn that she has health insurance, and therefore we're not dealing with Medicare, Medicaid. We're dealing with a private insurer that in turn tells us we're going to be able to get paid.
Correct. And we're going to be able to get paid more
Ah.
for private insurance than the entity would get paid for any state or federal assistance. So I know within the first 5 minutes, and that really is the intake that we allege, was really to get more about what her insurance is and what they're getting paid than they did to truly independently evaluate her mental health situation.
Now, let me just ask a question, and I don't know if this is relevant or not, but as they're looking to bring her, evaluate her, and admit her, is there a significant amount of space in the facility, or is it pretty much filled up?
The short answer is no. There's not a significant amount of space. And what we've alleged in the complaint is that this is a facility that is overpopulated and understaffed. It has been for years. That's been the condition that has always been the case, especially since UHS took over in 2014. And that's intentional on the part of PIW and UHS. That's what we've alleged. In other words, it's heads in beds. That's the corporate strategy for UHS. It's to increase occupancy and cut staff and resources, right? And in doing so, to increase shareholder value. And that's, UHS has been very public about this. This is not us providing color commentary. This is based on the public statements by UHS's executives in earnings calls and in other public fora. So that is the strategy, and that's very much consistent with what our client confronted when she was admitted.
So I'm going to take a wild guess that this is not the first time that these folks have either been sued or investigated for incidents similar to Jane Doe's.
You are so right, David. I will tell you that probably, somewhere around 20 pages of our 75-page complaint talks about the previous investigations that PIW and UHS have been under at state level, the federal level, the DC city level, and not surprisingly, tying it to what I do normally for my day job is represent whistleblowers, UHS and PIW were investigated by the federal government, and in 2020, they settled a False Claims Act lawsuit for $122 million back to the federal government. PIW was included in that, and that was for a period of time from 2006 to 2018. And so that period of time, the government was alleging at that time, and the defendants paid $122 million to make this case go away. The allegations were, though, that patients were being sort of systematically mistreated, that patients were being admitted who were ineligible to be admitted. So very much like our allegations with Miss Doe, that she did not meet the suicidal sort of ideation criteria. The government found that PIW and UHS had failed to provide adequate staffing, failed to provide adequate training, failed to supervise their staff, failed to supervise the patients, billed for services that were not rendered. It goes on and on and on. Improper use of physical restraints. It goes on in terms of the allegations that the federal government brought. And again, that period covered 2006 to 2018. We sort of are picking up now with Miss Doe in the last 3 years. So we filed this case a couple of months ago at the very beginning of 2025, and we can go back 3 years from that. So although the government has investigated and settled this, that ended in 2018. with PIW and UHS entering into what's called a corporate integrity agreement, which means that the government monitors UHS and PIW going forward. They're supposed to monitor them going forward for a period of 5 years. Our allegations are that obviously there's some overlap there. And while they were under this corporate integrity agreement, we're alleging that if they had changed at all, they slipped back into their old ways, or maybe they never changed at all, right? Our allegations were that everything that the government sort of found and alleged back on that False Claims Act case, Ms. Doe is finding again much more recently. And we are hearing from even more witnesses and patients that allege that this is continuing through today.
Okay, so, Veronica, you mentioned working on whistleblower cases, and this is somewhat different. So, executive summary, what's a whistleblower case, and how does this differ from that?
Yeah. So a whistleblower case is usually somebody internal. What we think of when we hear that in the news, whistleblower is usually someone internal. So it can be a nurse, a doctor, a staff member in the coding office, a compliance officer, anyone. It could be a patient. It could even be a competitor. But for the most part, it's somebody internal, an employee or a patient who's working at some place and who realizes that they think the company is engaged in some sort of fraud, whether it's criminal or not, some sort of improper behavior. And that has something to do with a federal or state funds. And so the healthcare system, everything does, right? Everyone just about every sort of provider, especially at a hospital like this, is going to be a Medicare provider and a Medicaid provider. And so when that happens, when you have a defendant like this who is alleged to have been billing for services they didn't give, that means that Medicare and Medicaid are using our tax dollars to reimburse these defendants for services they never gave the patient. So who makes out there, right? The patients don't make out. They don't get the services. The taxpayers don't make out. Our taxpayers just going to line the pockets of these defendants under that scenario. The defendant's the only one who makes out. But that case was brought by usually a citizen, a whistleblower, is really brought on behalf of the governments because it's the government that overpaid. It's Medicare, it's Medicaid, it's TRICARE. They're the ones who overpaid, so that's their claim. So when I'm talking about, the government having sued them and settled for this period 2006 to 2018, that was because that was the federal government and the state's government claim. Very different in a class action now where we have an individual who, by the way, is unbelievably brave to come forward and say that this happened to her, and she's not bringing this class action on behalf of the government. She's bringing it on behalf of herself and other patients who were similarly situated within the same time period and who may not even know that there is a class action case. They may not even know that there's a potential for them to join a class. It doesn't have to happen. As long as you have at least one person to bring forward this case, then we hope that from the plaintiff's side, we hope that it gets certified by the judge and that it turns into a class where it would be able to encompass all the similarly situated patients who were at PIW within the time frame.
Okay, so Drew, what's the end game here? What's the goal of this piece of litigation?
So largely, this is a claim for damages, right? So our client.
What's that mean? Again, remember, people. When you say damages, what's that mean?
So these would be civil money damages. There's really two types of relief that we're seeking here, right? There's monetary damages, and then there's injunctive relief. So that would be to actually have the court order PIW and UHS to either do something or stop doing something. That's largely what that means. But the crux of the case is a money damages case. And so our contention and our allegation is that Ms. Doe has been damaged civilly in that she's suffered civil harm and therefore has a claim to monetary damages to compensate her for that civil harm. And that all other similarly situated class members also have claims for civil damages. So, under the civil justice system, usually the only remedy we have is money. Nobody's going to jail for this. There's no imprisonment. It's really monetary damages, and that's how we hold wrongdoers accountable, and that's how we compensate victims of civil harm. So that is certainly the focus from a damages perspective and a remedy perspective. That's the focus here. It's to bring that level of justice to our client and all other class members that hopefully the court eventually certifies.
And also to preclude them from doing this to other people, right? And that's part of what you're trying to accomplish, I assume. We don't want any more Jane Does getting locked up for no reason because their husband said they're crazy.
Right. That's the sort of the next level. So yes, the sort of micro focus here is to try to get civil justice for our client and class members. But then what we certainly hope in a case like this is that we are able to change corporate behavior, that we're able to regulate, if the government's, not going to do it, or maybe they're limited in what they can do, to regulate the corporate behavior of UHS and PIW and make sure that moving forward, they're prioritizing the well-being of their patients over their bottom line. And that's ultimately what we want to try to achieve in this case from a macro standpoint.
Okay. So if there are folks out there who are either patients at PIW or new people that were patients at PIW over the last 3-4 years, whatever it may be, what, if anything, ought they do now that they're hearing all of this?
We would certainly recommend that if they want to discuss their legal rights, to contact us. That's sort of the first thing. If they're interested in discussing their legal rights and potentially pursuing a legal action or being part of this class, we'd also recommend that they try to get their medical records from PIW and their medical bills. They can get their medical bills either directly from PIW or from their insurance company, regardless of whether that's private or public payer. And then, they can reach out to us and we're happy to discuss their rights and their story and hear their story and learn more about what happened to them.
And are you just looking at PIW here in the district, or are you also interested in speaking with folks who have been patients at other UHS facilities, wherever they may be in the country?
I'll tell you that without asking for it, we've been contacted by, as you can imagine, David, some folks from other UHS facilities. Like Drew said in the beginning, UHS is the largest, I think, sort of parent and provider of mental health facilities, definitely in the United States. And then they've also gone global. So they have several psychiatric entities, very much like PIW in several states. And if somebody knows of someone who was in one of those institutions who faced some of the very similar facts to what Miss Jo is talking about, what we've been talking about here today, we do recommend that they contact us, and we are happy to speak with those folks as well for a few things, right? First of all, we want to see if there's a way that we can help other folks who might inquire, whether it's through this case or through a different potential case or a different avenue. We will check that out for them. And we also want to see, obviously, if there are other people in there who maybe for one reason or another missed out on themselves being able to go after and pursue a claim. Maybe it's been too long, for instance, or something like that. But they may be willing to talk to us nevertheless about their experience, and they may be willing to be a witness or to support this case. And we've had, frankly, calls and inquiries over the last 3 to 4 weeks from everyone that, sort of runs the gamut in there, and it's been encouraging. I think the other thing I was going to say, David, is that this is, I think, really filling a gap that's out there, right? We had all of the different federal government and state and even the DC Council, investigating, having these findings that they make and these suggestions for going forward. They have this big case that they settle for $122 million. But those were all about sort of what was happening, more of the macro level that the governments are looking at. None of those investigations or settlements led to $1 in the pocket of a patient, right? So our case is trying to sort of fill that gap where there's been all this stuff about this before, but nobody's really brought this action from the patient's perspective and to try to put some dollars back in the patient so that, for instance, if they have PTSD as a cause of going through this, we think they should be able to get some civil damages from that and be able to pay for a therapist or whatever they need to address the traumatic situation that they were put through at PIW. And so, we're really sort of patient focused on this. Obviously, those are our clients, and telling their story and getting them as much justice as possible, both at PIW and elsewhere, if it turns out that something similar is happening in other UHS facilities.
We believe the damages are significant here. And I think it's important to realize when we talk about involuntary commitment, what we're talking about a complete restriction of freedom. And outside of jail, right? And I mean, this is really the only time this happens civilly in this country is through involuntary hospitalization. And so we believe that certainly Ms. Doe has alleged, and that there's many, many other people out there like her who have had their freedom taken away under false pretenses, through falsification of records, and that when they've been put into this system at PIW, they have not received therapy, they've not received treatment, they've not received any benefits that PIW and UHS are required to provide under law, both federal and District of Columbia law, that they've been subjected to unsanitary and unsafe conditions, that they haven't been allowed to go outside and breathe fresh air for days and weeks at a time. I mean, we're talking about what we believe to be very serious claims and that warrant substantial damages to our client and to the class of folks. I know that some people maybe think of class actions and they think of, oh, well, you file your claim and then you get a check for $13 a couple of years later, right? We're not talking about that type of class action here. We're talking about a very serious, and not to cast shade on those types of class actions, because they certainly do have a role in our justice system. But in this particular case, we believe the damages are very substantial.
Yeah, we're talking about imprisonment and not allowing Miss Doe to talk to her attorney, right, to get her out, which you would even get if she was being held by the police. So really substantial, really significant constitutional violations.
You mentioned class action, and again, a lot of folks that listen here are not lawyers, and you're right. They read something in the newspaper, they join a class against Nissan or whoever. They get their $9 check after $7 years, whatever it may be. But what just, if you can, is as dumbed down as possible. That's a bad term, but in terms of layman's terms, what is a class action? What is it exactly?
Class action is a creation of civil procedure. So it's a type of case that is actually prescribed in the rules of procedure in our court system that allows a single person or a few people to file a case on behalf of themselves and many other people who are similarly situated and have the same claims and causes of action against the same people or entities. So it's a way of basically taking hundreds or thousands of individual claims and putting them into a single case. And it's designed as a way of building efficiencies into the system so that you don't have hundreds and thousands of cases out there kind of in different courts with different rulings and different damages awards against a single entity. When we pursue these, there's certain requirements that you have to hit in order to have a class action certified by a court. In other words, the court says, yes, this is a class action and it can proceed. And so, you have to establish that the class representative and the plaintiff or plaintiffs are adequate, that they have the types of claims that everyone else has, more or less, that the claims are typical of one another, that there's commonality in the facts between the class representative and the class itself, and that there's a sufficient number of people that are being alleged to be part of this class. If you check those boxes, then, hopefully the court would certify it and you can proceed as a class action.
Yeah, I mean, it's going to show my age a little bit, but I keep thinking of some movies, right? One Flew Over the Cuckoo's Nest. I think of The Snake Pit, which goes back even further than that. I don't know if you guys saw either of those, but people who have mental illness, are of the most at-risk members of our society. And what you're laying out for me, and I'm sitting here, the hair on my back is standing up when I hear about how she ended up in there to begin with. What you're laying out here for these folks is this institution taking extreme advantage of people who are, in some cases, of the most risk, a class of the most risk of our citizens here. And from my perspective, you couldn't be doing better work than what you're doing. Now, we'll know where, in terms of this case, where does it stand? What are the mile markers, so to speak, that you look for in terms of, class actions and this case particularly?
Yeah, we filed in the very beginning of February. And as these things go, and this is a boring part of law, but we serve the defendant. So basically telling the defendant, hey, you've been sued and here's a copy of the allegations, here's a copy of the complaint. Right out of the box, defendants, and we know that they're going to do it in this case, they get to file something in court called a motion to dismiss. And what that does is it's their attempt right out of the box to get the case kicked out completely. And so they want to say, hey, we see what you've alleged here, but this is, you're not, judge under the law. even if what they're saying is true, there's no case here. Throw the whole thing out and let's send them packing. Let's not waste your time, my time, everybody else's time. So we know that the defendants are going to do that here. Every defendant does it, and we're waiting on that. So that's really the first hurdle that we have to clear. We are very confident that we will clear it, but it's something that we have to clear, something every plaintiff has to clear kind of out of the box, usually before we get to serious discovery, which is when we get to get their documents, we get to put their people under oath and ask them questions in a deposition. We get to show them their own emails and make them explain, show them their videos, show them their text messages and anything that we have, and make them explain what they're doing. And they get to do the same thing with our clients. And so, but before we get to that exchange of information, that discovery piece, we do have to get past this first hurdle.
Gotcha. Okay. And if folks want to speak with either of you or anyone on your team about what they may know or what they may have heard, what's the best way to get hold of you, of the two of you?
They can reach out to us. Probably the best way is to reach our main line, which is 301-220-2200, 301-220-2200. And if they call that number, they can get transferred to me or Veronica or any member of our team. They can say that they want to talk with a lawyer about the PIW case, and our receptionist will know where to send them. They can also go to our website, which is jgllaw.com, and they can submit a confidential online inquiry with the same type of information. And folks may feel more comfortable doing that in a case like this as well.
Okay. Thank you. I want to thank you, Veronica. Thank you, Drew. Folks out there are times in life when you need to stand up. Stand up for yourselves, stand up for others who may come after you. Contact Veronica, contact Drew if you know anything about this hospital, this entity, this organization. I am David Bulitt. This is JGL Law for You.